who do you think you are? I've had a bunch of them around here. So crossed off the ones that should no longer be on there. Oh, thank you. There might be one more. It will be
Good morning, ladies and gentlemen. This is the people of the state of California versus Eric McKinley, Cameron Leahy, James Fisher. The docket number is 24CR004218AB. Counsels, please state your appearances for the record.
Your Honor, Simone Spector on behalf of the people, and Alex Manifesto is Statute of the people.
Good morning, Your Honor. Julia Fox on behalf of James Fisher, who is present and out of custody.
Good morning, Your Honor. My name is James Shore, and I'm with my client, Mr. McKinley, who is personally present for today.
Good morning, Your Honor. Allison Berry Wilkinson on behalf of defendant Cameron Leahy, who is also present and out of custody.
All right, good morning, counsel. Hello to the charged defendants. This case has been on this calendar for a motion to dismiss by the defense for a violation of the statute of limitations in this case. There have been briefs filed by both parties, which I've read. I've also read all of the cases that have been cited in those briefs. I will give you an opportunity to argue further before me, but I did have a couple of things I wanted to make clear for the record. In this case, the statute of limitations is 3 years for a charge of 192. Do all parties agree to that?
Yes, Your Honor.
Yes.
Yes.
Yes, Your Honor.
This case was filed by way of a complaint 1 day prior to the expiration of the statute of limitations. Is that correct?
Yes. Yes.
Yes, Your Honor.
All right. So there was no arrest warrant issued in this case. Is that correct?
Correct.
Correct.
Yes.
There was also no criminal summons issued in this case. Is that correct?
That's correct, Your Honor.
All right. Now, in your brief on behalf of the defense, you mention a case law that deals with the complaint that is on its face violative of the statute of limitations. And in that situation, the burden of proof is on the people to show that, in fact, the statute of limitations was not violated. Yes?
Correct.
That is not what we have here, though, because on the face of this complaint, this case was charged within the statute of limitations, correct?
It is our position, Your Honor, that on the face of the complaint, it is defective and subject to demur because they did not state the required elements pursuant to Penal Code Section 804 or any exception thereto.
But a charging document that's filed within the statute of limitation is not on its face violative of the statute of limitations.
That would be correct, Your Honor.
And it seems to me that's what we have here, and that issue is important because it changes the burden of proof. If the charging document is on its face violative of the statute of limitations, then the people have the burden to show that it is in fact not in violation. In this case, where the charging document itself indicates that it is within the statute of limitations, the burden is on the defense to show that in fact there's no triable issue of fact as to whether this prosecution proceeded as that term is understood.
Correct, Your Honor.
All right. So on the people's side, you spend a lot of time citing the People v. Gorley case, which is curious to me for a number of reasons. One, that case is a decision by a superior court out of another county, not Alameda. So it is not binding on this court in any way. Also, that case does not deal with the statute of limitations issue. It deals with whether a section having to do with the notice to appear was violated in a misdemeanor complaint. And hence a misdemeanor complaint, unlike a felony complaint, a misdemeanor complaint starts the criminal process for the purpose of speedy trial and statute of limitations. So the Gorley case does not seem to have any precedential value in this case. So I'm curious as to why so much of your brief relies on that.
Well, Your Honor, I think that this situation is, there isn't much case law that would reflect our particular fact pattern. And so we searched for cases that could be persuasive and help the court make a decision in these unusual facts, with these unusual facts. And so we cited that because we felt that it was persuasive in terms of the idea of the defense having notice, and that we hoped and felt that it was persuasive.
You also draw an analogy between an arrest warrant and the probable cause declaration that was filed in front of Judge Condis, where after reviewing that, she signed that document saying that there was probable cause to detain. And you argue that that is functionally equivalent to an arrest warrant. Is that your position?
Your Honor, I think within the totality of all of the documents that were filed together, that while we recognize that this is not a arrest warrant, but that all of these documents together show that there's probable cause, which is what the legislature, one of the intents of the legislature, and asking for an arrest warrant to be issued, and that when a judge finds there's probable cause to detain and offers to sign an arrest warrant, and it was decided not to do that, that the functional meaning behind that was met. And obviously it creates a situation which, in retrospect, it would have been more expeditious to ask for an arrest warrant. However, it didn't happen, and here we are today, but we believe, and that's been our position, that all of these documents taken together did meet the requirements that the defense counsel complained about that is in the 804.
All right, your brief seems to take the position that this case is about notice and that the defendants had notice.
That is one of our arguments, yes.
All right, so that's not really what the statute of limitations is about, is whether the defendant had noticed or not. It is whether the case proceeded, the criminal process proceeded within the statute of limitations, which means it has commenced.
Correct.
It's not a question of notice.
And we believe that the probable cause that was found in the probable cause declaration helps to show that it commenced.
Well, what the judge indicated is there was probable cause to detain somebody, but that cannot be interpreted to mean that there was probable cause to arrest somebody, because a detention can be based on reasonable suspicion, which is a lower burden of proof. Now, in your brief, you cite to the probable cause declarations that are signed by judges, which I sign hundreds of them a year. Those probable cause declarations serve a completely different purpose than an arrest warrant. Those probable cause declarations are filed after somebody has been arrested without a warrant, and the courts are concerned about the requirement to have somebody arraigned within 48 hours of their arrest. And when that can't happen, a judge has to review the facts of the detention to make sure that somebody's not in custody beyond those 48 hours after a judicial office. It makes sure that a judicial officer has looked and said, yes, there was reasonable cause to detain this person. So that probable cause declaration that you cite to is not dealing with the same issue as an arrest warrant. So those are kind of the principal questions I had concerning your brief. But the burden is on the defense in this case. So as I mentioned, I have read the briefs in your case. Is there anything else you'd like to tell me?
Thank you, Your Honor. Just very briefly, simply to note that the key component from Penal Code Section 804 is the requirement, the only one they could have met here, was the requirement of an arrest warrant. And I don't know that we highlighted sufficiently in our brief, so I'll just bring it to your attention now, that under Penal Code Section 813, it says that where a complaint is filed charging a felony, the magistrate shall issue a warrant. So between Penal Code Section 804 and warrant nor a summons issued here.
So I'm well familiar with the concept that a filing of a criminal complaint in and of itself does not commence a criminal prosecution based on a long line of speedy trial cases that deal with that issue frequently both in the California courts as well as the United States Supreme Court decisions on that. Anything else before I turn to the people?
Not from defendant Leahy, Your Honor.
Your Honor, on behalf of Mr. McKinley, I do want to touch on one thought if the court is considering or may consider granting our motion, which is the issue with regard to him about leave to amend. As we all
And
know,
he is the defendant who was out of the States on a mission for several months.
that's correct.
Go ahead.
As we all know, the role of a prosecutor is unique in the justice system. And as we cited in our brief, prosecutors are ministers of justice. They have an obligation not only to the people, but to the defense, and to see that the defendant is afforded procedural justice as well as substantive justice. And their conduct in this case has so infected the process that when we look back at the actions of the district attorney in this case and the misrepresentations that were made, at this moment, I don't know if those misrepresentations were made because of negligence or were made for other reasons. But nonetheless, we all know now that those misrepresentations were made. And that so infected the process, and that is the only reason that they even gained the knowledge that the court alluded to just now about the fact that my client was out of state.
By misrepresentation, you're referring to the fact that Ms. Abrahamson filed a document that said a summons had been issued?
And failure to appear that an arrest warrant would issue. That's correct. So, when we look at due process as a concept the court's well aware of, we look at fundamental fairness. And so it is our position that it is fundamentally unfair for the prosecutor, if the court is going to dismiss the complaint, it's unfair for the prosecutor to be given leave to amend to fix something that they gained knowledge of through this, for want of a better word, deceitful conduct. So we're asking the court to consider that along with everything else that we've written, and ask that the court, we're inviting a motion pursuant to Penal Code Section 1385, and the court ultimately dismiss this matter in the furtherance of justice.
All right. Thank you. Ms. Fox?
Nothing further on Mr. Fisher, Your Honor.
All right. And from the people?
Your Honor, to address the arguments that Mr. Shore made, I suspect, with all due respect to those arguments, that we would have learned of Mr. McKinley's departure from the state and country, regardless of what format this had been filed. That would have very likely come to our attention. And so while I understand that that's disappointing for that defendant, I don't find that argument persuasive, that they should be given any special consideration in light of that argument.
So, this case was reviewed by the prior district attorney, and it was determined that there was insufficient evidence to file a criminal complaint. Ms. Price became district attorney in 2023, and she re-reviewed this among many other cases. I see from the brief and as well as the probable cause declaration that an expert was hired to review the police activity in this case, and I would say very qualified expert based on the CV that I reviewed, and ultimately he determined that they didn't use correct procedures, that they should have been trained to know that what they were doing was dangerous, and that report was finalized according to what was submitted with this brief, February 17th of 2024. That presumably was in your possession 60 odd days before this complaint was filed. I'm just wondering why the 60 days? I mean, why wait to the day before the statute of limitations? And this goes to a prosecutor upholding the highest ethical standards and pursuing justice, not pursuing individuals.
Your Honor, not anymore. As I was not involved, I had just joined the office at that time. It is my understanding that we were still working on getting that document and wanting to have a final version of that report.
All right.
There are other procedural reasons within our office why we couldn't proceed earlier, but I don't think they belong in this court today. But I think that it's unfortunate that it took as long as it did, but it was not due to, I think, any mishandling on the district attorney's part and our office's part. It unfortunately there were a series of events that caused it to take longer than we would have liked.
All right. Is the matter submitted?
Yes, Your Honor, as to Mr. Fisher.
Yes, Your Honor, as to Mr. Leggy.
Yes, Your Honor, as to Mr.
Submitted, Your Honor.
All right, so the court is going to take this matter under submission. I will make my ruling via the Odyssey website with an order, and that will occur prior to October 2nd, which is your next court date in Department 112. We are adjourned. We are going to take a brief recess so the courtroom can clear, and then I'll take the bench again and call the balance of my calendar.
Your Honor, if I may be heard very briefly.
Yes?
I believe our next court appearance is October 11th.
Ah, okay. I stand corrected. So the next court date is maintained. It's October 11th, Department 112. I'm assuming it's at 9 o'clock in the morning?
Yeah.
All right.
Your Honor, would the court be willing to allow us to move that date for entry of plea and also move the date for booking for each of the defendants?
So that's fine with me if you've conferred with